hearing for the Chapter 353 development plan for the Manchester Road flood mitigation area, the Brentwood Redevelopment Corporation, and our city holding a public hearing tonight to discuss the Chapter 353 development plan of Manchester Road. We have three presenters: Chris Jones, who's the president of the 353 Corporation, John Brancaglione from PGAV, Jim Mello, our counsel, as we gavel in this public hearing at 7:20 also. First up, Mr. Jones, if you could, please.
Good evening, and thank you, members of the board. My name is Chris Jones. I live at 2657 Salem Road, and I have been involved with the Brentwood Redevelopment Corporation for years. Currently act as the chair of the president. As I think most members are aware, the Brentwood Redevelopment Corporation has been looking at a Manchester renewal project for some time. So with me here this evening, I have John Brancaglione, who's going to give you some information and be prepared to address any questions that the board or the public may have about the work there. Upon conclusion, I think later on the agenda, I think you have on your agenda a motion for the acceptance of both the development plan as well as the qualification analysis. I would ask that you would accept those later on. So without further ado, I would like to introduce John and to let him to address any questions that you might have.
Awesome. Thank you, sir.
Thank you, Chris and members of the board. You have, as a background to this, two documents, both prepared by us on behalf of the city and on behalf of the Redevelopment Corporation. First document I want to talk about, because one thing sort of precedes the other, is the qualifications analysis document. In order to create a Chapter 353 redevelopment area, you have to make certain findings that are backed up by evidence to declare the area as a blighted area. Now that has multiple meanings under the statute, but I'll walk you very briefly through what we found having visited this area numerous times over a one-year period. The area boundaries are shown on the plate that is at the appendix to the Appendix A, which are the supporting exhibits. And so the boundary generally includes the parcels fronting Manchester Road between roughly Mary Avenue on the west and Hanley on the east, and to the city's limits on the south. The area contains 91 parcels and 91 acres of territory. The existing conditions that I will recite in general are shown on a map that is plate 4. The existing conditions, and that plate is specifically designed so that you can see the number of factors that were present on any given parcel. And then that is backed up by a table, Table 2, again, that provides the same information in table format. This area is one that you have, as a city, been working on for a very long time. The area has flooded 26 times since 1957, and much of that accelerated and is compressed into about the last 10 or 12 years, where the flooding frequency has become far greater. And of course, you all know what happens when that occurs. Basically, it shuts down Manchester Road, it floods properties, and generally creates a fair amount of havoc until the water finally recedes. This is an area that is part of 3 component projects that you have dubbed Manchester Renewal. I'll talk about those when we get to talking about the development plan. One of the factors that Chapter 353 requires there be a finding relative to is age, the age the age of buildings. And so the way we look at that is really hooked to the way the federal government looked at that under the old urban renewal statutes, where there was sort of a demarcation that said if the building was 35 years old or older, it was likely at a stage where it needed more than a little attention, particularly in instances where there hadn't been active and ongoing maintenance to that structure. So in this case, based on the assessor's data, 83 of the buildings, or 92% of them, are older than 35 years of age. Only 8 buildings are newer, and those were buildings that were built basically between 85 and 99. The average building in the area was constructed 58 years ago, and some of them are more than 100 years old. The other factor it looks at is, that we're required to look at, is obsolescence. And so what you can see if you study the mapping is some very weird parcel configurations in numerous instances, where if you tried to build something on that parcel today based on your current codes, it would be very difficult to do that, or the planning commission would be holding board of adjustment hearings on an ongoing basis. There are utilities, curb cuts, site access, all sorts of things that confound the ability for these properties to function. And part of their obsolescence is a function of what I'll call market rejection, for lack of a better term. We have a lot of vacancies in this area, and the reason you have those vacancies is in part because there's this flooding thing. And that means that people are reluctant to either become tenants in or purchase those structures. You have other factors, including the sort of angled configuration of the intersection of Manchester and Hanley. That creates a traffic constriction, and so some of these factors that go to obsolescence, for example, you have industrial buildings in particularly the southern part of the area, and retail buildings in the northern part of the area that don't meet modern standards. They're simply old buildings that are difficult configurations, are broken up internally, and then even the industrial buildings in many instances don't have the clear heights inside that are typically desirable in that market today. Some of these things also factor into another category called inadequate or outmoded design. So that relates to things like the odd-shaped parcels I was talking about earlier. Small buildings that nearly cover a parcel, and so now you've got constraints on the ability to have sufficient parking for the use that's there. There are a lot of vacant buildings, and you have some infrastructure that includes electrical, water, sewer, stormwater, all of these things that now are outmoded from a design standpoint, as pretty much any public works or city engineer would tell you. So part of that gets affected by, again, this flooding problem. The most recent two that we cited here were December the 26th of 2015 and October 18th of 2016. Now, that has contributed, both the age, the outmoded buildings, and the flooding have contributed to the physical deterioration. And that's pretty much all of the things that you might expect to see as a result. Parking and paved surfaces that are deteriorating, and roadways that are deteriorating, subject to these areas to flooding often enough, and they simply begin to deteriorate more rapidly. This has affected the infrastructure, the storm drainage. Part of the storm drainage issues there are the fact that the creek has been allowed to fill in over time, both from the standpoint of dirt and debris infill that comes every time it floods, but it's also has significant overgrowth. All of that is contributing to the problem that you have. Then once you looked at those factors, the statute says, okay, to what degree have these attributed or contributed to economic liability? Well, the assessed value of this property in the area reached a peak in 2008 during the housing and real estate bubble, but it's seen a 14% decrease since that time. And even prior to 2008, the numbers weren't going up at a significant rate. And you can see there's a table on page 9 that shows you it was like a spike, a one-time spike, if you will. And it's pretty much been a downhill run ever since. And, you know, this trend is in stark contrast to the rest of the city, where the citywide real property assessed valuation over 10 years has increased at 32%, while this is going down the other way. The social liability factors, as have been determined by both the statute and ongoing case law on 353, means that a primary social liability that's related to the decrease in assessed value is such that you have many of the taxing districts who are providing a social service of one sort or another. So you have, in my mind, a social liability when that revenue is decreasing and is on a continuing downhill run. But in this case, you have other environmental factors which are important in making that argument. And of course, we've already talked about the floodplain, so I won't go back into that anymore. There's been an ongoing pattern of illegal dumping in the area. There is documented, and I was surprised to find this, we have flat employment data in there because, again, as those businesses and buildings have become vacant, that means somebody's not got a job there. The other thing that has occurred is that we were shocked to find the EPA data that shows what is coming down that creek every time it floods, and it is not pretty. And page 12 of the document bears that out. Plus, depending on when you visit this area, and even after a normal rain, there's a lot of standing water. And so nowadays, as we pay much more attention to things like the Zika virus in West Nile and the mosquito breeding grounds, if you know what you're looking for, you can literally see it. And as we indicated, there are conditions that are conducive to crime anytime there is, in fact, vacant buildings. That's sort of what sure your police call it, attractive nuisance. And as I said, there's evidence of trespassing, graffiti, illegal dumping, and some evidence that some of it may have been industrial waste. Although we didn't see anything that looked like that the last time we were out there, which was about 4 months ago. So, we believe the area qualifies by virtue of age, obsolescence, inadequate and outmoded design, physical deterioration. And then those things, the economic and environmental conditions represent both social and economic liabilities, not just to the city, but to the taxing districts and the various property owners in the area. And we have provided a sample of photographs that we think represent sort of the cross-section of conditions in that area. There are way more photographs than are here. So we chose to pick the ones that we thought were the best examples of the recurring items. Do we have any questions on that info?
Questions for John?
Okay,
Outstanding information.
Then I will go on to the development plan. You have created a 353 redevelopment corporation and established that board. And in this case, like others, you are not unique in this. That entity is acting as an overarching city-created, what I would refer to as master development. At the end of the day, that board will undoubtedly develop nothing. But they're there to facilitate really two things. The land acquisition process that has to be carried out here to implement the flood mitigation design that is now in its final stages of engineering, to assist with any land acquisition relative to the city's contribution to the Manchester Road improvement, because the city is intending to do some enhancements of its own as part of that piece of the Manchester Renewal Project. And then thirdly, the Great Rivers Greenway project that the city is also participating in to implement the extensions to the existing trail system through the area. So what the development plan does is it establishes the basis for the quote-unquote redevelopment project, whereas these projects are implemented and there is an opportunity to redevelop the area, what this anticipates is the redevelopment corporation will be the city's entity overseeing the land acquisition process on behalf of the city and this board. And then once those activities are completed, and it may be staged or phased, then they will be the entity that solicits proposals for redevelopment for particular pieces of the area from either existing property owners or third-party developers, and be the entity that sort of vets and screens those proposals before passing them on to you. Any redevelopment in this area ultimately also has to be approved by this board. So they're playing a role that is right and proper, and it's been very successful in other cities. If you're familiar with a large business park project in Maryland Heights, on the north side of Page and just west of Lindbergh called Lakeside 370. That was done in much the same fashion, initially using in that case, they used the Industrial Development Authority members and had them wear a different hat and created them as the 353 board, basically following the same procedure here. The development plan sets forth the project construction costs that are related to those major developments, and those are based on the current data from the city's engineers, from MoDOT's engineers, from Great Rivers Greenways consultants, and the overseeing entity, which is Navigate Building Solutions, which is the umbrella agency the city, or entity the city retained to oversee this whole process. So this development plan in our mind and per your counsel, Mr. Mello here, meets the provisions of the statute, provides for things to be done the way this is intended. And so I think this is a complete package that marries these two things together. I'll be happy to answer any questions.
Thanks, John. Any questions? Alderman Lockmiller.
John, the properties that are outside of the flooding area, but yet we're looking to also blight, is that mainly just due to the obsolescence of the properties?
In some cases, yes. In fact, in many cases, yes. But some of those buildings may be functional, and there may be businesses there that want to redevelop them. In other cases, there are a whole string of vacant buildings along the north side of the street there. And so it's hopeful that this, because there is the ability later for the redevelopment corporation and this board to provide tax abatement in exchange for a good redevelopment project, that you will be able to assist not just a third party, but maybe assist an existing business.
And does the 353, are they the holders of the properties we acquire? Or is it under city?
The city ultimately will be the entity who takes title to the property as far as the three projects are concerned. Ultimately, if the 353 board then in turn down the line approves a redevelopment proposal for some independent entity, in other words, a third-party developer that wins your favor and their favor as a developer, then they have to form their own 353 redevelopment corporation in order for any of those incentives to be transferred on. Am I right, Jim?
No.
Oh. That's why he's here.
Any other questions for John before he steps down?
Well, we should make sure they can pass the development, the board can pass the development rights on, is that correct?
Well,
Jim, come on up if you can, please.
Yeah, go ahead.
John and I have done this a few times, and I have to keep reminding him he's not an attorney, and he's got to keep reminding me that I'm not a planner. So we kind of go back and forth. But just in response to your question, most of the property will be titled to the city. So it'll be the corporation would be acting as an agent, third party, going under contract, and then transferring that title to you. Down the road, depending on how everything ultimately shakes out and the public facility improvements are in place, as John indicated, there could be third-party developments that occur, like somebody that's an existing property owner redevelops a site and buys adjacent properties or buys surplus property from the city. Title would have to go through a redevelopment corporation. I would suggest that that would go through the city's redevelopment corporation because it would be part of a redevelopment plan. But by state law, title has to pass through a 353 for tax abatement to apply. Now, it could be a third-party 353, but why would a developer want to form its own 353 since the city's 353 was already pretty much in charge of overseeing the project to begin with? But if you remember Drury's project, that was a separate 353 that was done by Drury Corporation.
Yes.
Because the city 353 had no involvement in it. It was a totally private development. One point I do want to make, though, is that the current plan does not provide for any tax abatement. So any tax abatement that was going to be proposed down the road as property is reassembled as proposals are made would have to go back to be recommended, come back to the Board of Aldermen. The taxing jurisdictions would receive notice and a tax impact report so that the school district and county would know what impact they would have if the project was approved. So I just want to make sure everybody understands that it's not a part, they can't just start giving tax abatement. It's got to go through the process again. And that will happen, I think, after the initial phase of the public improvements are built and we start seeing interest by third-party developers in this area once the core problems have been resolved.
And we do have a representative of the school board on the
Yes.
353.
Yes.
Thanks.
Alderman Pluska.
Thank you, Mr. Mayor. So as we take this up as Bill 6200 tonight, if we vote to authorize approving the 353 development plan, then they become a separate corporate entity that then would, at the appropriate time, take on the sort of the discernment of various redevelopment proposals when the timing of that is correct, is appropriate given, the abatement, the other things that are being done, the flood abatement, the other aspects that have already gone into. So let's say that 353 Corporation at some point down the road says and makes a decision among its board that one particular redevelopment plan among other redevelopment plans is the one that we think, or that corporation believes this is the direction we ought to go. Is their relationship to this board similar to planning and zoning is to this board, or do they have separate and autonomous authority by virtue of this bill and ordinance to make deals and authorize the sale of property and things like that?
It has less autonomy than a P&Z board has.
Okay.
It cannot grant tax abatement unless the Board of Aldermen approve the underlying plan and the tax abatement. Now, and the acquisition of properties is going to be with city funds. So
Right.
the city's going to control the disposition of those properties.
Okay.
So, is it possible to concoct a situation where the corporation would have acquired property without the city funds or whatever, and could they then transfer that property as a corporation to somebody else that you may or may not involve as a city? Yes, but they couldn't do it pursuant to a development plan. They couldn't do it pursuant with tax abatement. So it would just be as a private, one owner selling to another, and there would be really no benefit in that. So.
And so, but the way this is conceived of and the way that it's expected to go is more the way that you just described, not in that sort of one-off circumstance, but in the circumstance that they would collectively develop or consider and then promote a redevelopment plan that would then be brought to here as a presentation.
Yes, I think.
Okay.
John mentioned one example. Another example would be Chesterfield Valley.
Right.
And that was done with a TIF, not 353, but there again, the city used an Economic Development Council to act as a master developer, but all the projects were approved, zoning, tax abatement, or the TIF, all those were controlled by the city.
Okay.
What the benefit of this is we've got the ability to do the tax abatement, do the planning, do the property acquisition, so that's in place, but it's still subject to the city's control. That's what we're trying to put in place.
Thank you very much. Thank you, Mr. Mayor.
And I wanted to make one other comment about the blight. Not every parcel within the redevelopment area is qualifies. The state law requires that a preponderance of the property, or majority of the property qualifies. So if you're a property owner in this area, you may have a perfectly fine building, everything's fine, but because it's part of an overall redevelopment area that does qualify, that's why it's included in the plan. So I just want to make sure that's clear to any property owners or anybody that's concerned about that.
Other questions? Jim, when you have the designation of blight, let's say, for example, there is an ensuing development or development agreement that takes advantage of the presence of that designation. Is there an expiration before it has to be renewed? Can the blight designation stay in place for how long? As long as...
That's a determination of the city council.
Okay.
And the plans that are in place. There's a limit to how long a tax abatement can be provided for. So, but one of the reasons why the 353, there's two reasons why the 353 as the umbrella, I think, makes the most sense. One is what we're talking about is property values tied to real estate more than we're talking about sales tax and economic activity taxes that you would see up at Brentwood Promenade, for example. This is not going to be a retail big box development. So it's going to be primarily property tax driven. The benefits are going to be property tax, and the abatement is going to be property. So it's a 353. The second reason is this is going to happen over time. It's not like your typical project where a developer comes in and says, this is what I'm going to build. I'm going to build it in this period of time, and these are the incentives that are going to be in place to get it done within 20 years or 23 years is the maximum in a tip. We don't have that luxury because we don't know how this is going to evolve once we start putting the public infrastructure in place. So we need the flexibility of time to expand, to be expandable, which it is.
Okay.
So that's why that's another reason to do the 3 years. Because this is going to go on for well, I was going to say something like I'll be on a beach in Italy by the time this thing is done, but no, it's going to go on for a long time, and so we can't put deadlines on those type of use of those type of programs.
All right. Thank you so much for your time. And because we have this as a public hearing, is there anyone in the audience that has any questions of any of our presenters or about this topic? If so, now is the time to come forward. Going once, going twice. All right, we're going to close the public hearing for the Chapter 353 Development Plan. Thank you, gentlemen, very much for being here this evening.